My name is Andrew Cederdahl. I am an Equal Justice Works AmeriCorps Elder Justice Legal Fellow. That is officially the longest title that's ever been bestowed on another human being in the history of humankind. I am very happy to be here today to talk about something, I hope everyone could hear that, talk about something that is very important to me, something that is a very fulfilling work to do, and something that is a serious issue going on in Iowa and across the country, and that is elder abuse. So today I'm going to talk about a few things. I'm going to talk about how does Iowa law define elder abuse. I'm going to talk about who is prohibited from abusing older Iowans, and by that I mean how does Iowa law categorize who can commit elder abuse, what relationships are necessary to bring an elder abuse petition under 235F. That's going to be the statute that I'm discussing. This is a new statute from 2014 that deals with elder abuse. I'm also going to discuss financial exploitation in particular. Elder abuse obviously includes physical, sexual, neglect, those types of abuses. It's not always easy to figure out whether those things are, what's going on fits into those categories or not of abuse, but I think financial exploitation is one of those things that's pretty difficult for us to figure out whether that's happening or not under the law. So that's why I want to focus on that. I'm going to go through some hypothetical scenarios to show whether it is or is not financial exploitation, to kind of illustrate the real world, what happens with this law, how we can apply it. And then I'm going to give some information about this 235F petition that can be filed for relief from elder abuse. So let's start with what is elder abuse under the law. Again, I'm using 235F here. The first thing is physical injury, unreasonable confinement, unreasonable punishment, or assault of a vulnerable elder. Now, I do want to mention that this is physical injury to a vulnerable elder that is not otherwise covered by 235E. That is the dependent adult abuse statute that was in effect before 235F came about in 2014. So when I'm not talking about dependent adults here, I'm just talking about vulnerable elders, which I will define later. It could also include sexual abuse. We kind of know what that is, generally speaking. I'm not saying it's always easy to find out whether something is sexual abuse or not, but we kind of know what that is. Neglect, deprivation of the minimum food, shelter, clothing, supervision, or physical and mental health care, or other care necessary to maintain an elder's life or health by a caretaker. And then the one I'm going to focus on most, financial exploitation. So, as I said, who is prohibited from abusing older Iowans? This is, again, obviously everyone is prohibited from abusing another person, generally speaking. It would be immoral to abuse another person, but we're talking about the category of 235F. That could be anyone in a position of trust, confidence, or power. That's the way that the statute defines who can abuse, when we talk about elder abuse, a vulnerable Iowan. Could be family, and I'm going to get into what members of the family that could be, and it could be caretakers, as defined under the statute. That caretaker could be family or non-family. Okay, so that can include people hired to provide care in the home. It could be friends or acquaintances who assume that responsibility, someone who's taken some responsibility over that person to help with their needs. It also could include fiduciaries, that being a power of attorney, guardian, conservator. Interestingly, the 235F statute does not include the word fiduciaries under the caretaker language. However, we know that a fiduciary is in a position of trust, confidence, or power, generally speaking, so that's just kind of a weird way that they drafted the statute. So factually speaking, we could show that certain fiduciaries would be someone in a position of trust, confidence, or power over another person, even though the word fiduciary is not included in the definition of who stands in a position of trust, confidence, or power. So I just wanted to point that out. It's kind of a weird thing about the statute. Let me go over some difficulties that I've experienced, that I've heard other people experience when they fight the elder abuse that's occurring in the state of Iowa. The first thing is a lack of evidence. Whenever you bring a petition in court, including 235F, the petition for relief from elder abuse, you have to prove your case by a preponderance of the evidence. That's a pretty low standard. I'll get into that a little bit later. But it still requires that you carry your burden of proof. You have to prove your case. And sometimes all we have is one person's word. And sometimes, and there's other reasons why that one person's word might not be taken as seriously as it should be by our court systems, by our institutions, and by our police authorities. Another issue is credibility. So by definition, we're talking about vulnerable older Iowans here. So sometimes these people might have mental illnesses. They might have other problems with them that make us less predisposed to completely take everything they're saying on faith. That can be hard when we're investigating issues of elder abuse. It can be hard when we're trying to prove it to a court or to get other witnesses to help us out with that. It can be a big problem. Another problem that we're going to encounter when we're fighting elder abuse is ageism and bias. And that's going to be with everyone. It's going to be institutions, with our police departments, with our lawyers, our judges. There's going to be things that, we're thinking about it here in the abstract and in theory. We kind of know when I say here and we're thinking about it in an intellectual way, well, of course it's not true that family would never steal from an older relative or physically abuse their relative. We know that happens. Of course it's true that some younger caretakers do sexually abuse older, vulnerable Iowans. That does happen. Of course, people with mental illnesses aren't lying to us for everything they tell us. Of course that's not true. But when we're not thinking about them in the abstract and someone comes to us and tells us that, subconsciously sometimes those thoughts creep in. And that's just one of those natural things that it's really hard to fight elder abuse because it's hard to start because we can't even get past that bias. And that can carry over into our court cases, into our investigations and all that. So it's something we really have to be conscious of and we have to check ourselves whenever those things enter our minds. The other issue is a lack of resources. In our society, whenever a child is abused, it's all over the news. We're all concerned about it. For whatever reason, elder abuse gets less attention. Don't know why that is. That's just the way our society is right now. I don't think it's necessarily a good thing, but we devote more resources to that sort of issue than we do right now to elder abuse. That's part of why I'm happy to be doing this fellowship, because I can actually engage these issues and try to help out because there are some severe gaps. Some other issues. The victim might not know who to reach out to about this. There's so many organizations out there. Who do I talk to? Who do I go to? I'm hoping today some of the information I give out will help us have a starting place so they know at least where to go, where to start, so they can try to address these issues. Another thing that I've encountered and that I've heard other people have encountered is that the person who is victimized might be extremely isolated to the point where their abuser is the only person they interact with. And so now they're with the choice if they want to deal with this abuse. Do I want to get rid of the one person that I interact with by turning them in, or do I want to just kind of take the abuse so I'm not completely by myself? It's a very sad dilemma, but it definitely happens. And it's especially heightened whenever we're dealing with family members. Sometimes, because we know financial exploitation, a lot of that's coming from our own family. So sometimes, even if we want to stop the abuse, we don't want to get our son or daughter or grandson or granddaughter in trouble. So we're very reluctant to even address it. Okay, so we might let it go on, or we might not get our money back if it's been stolen from us, for example. Sometimes older Iowans don't want to even admit that they have been victimized, because doing so, they think, opens them up to more scrutiny. Do they need to be in a home? Are they not taking care of themselves like they need to be? They got swindled so easily by this other person. That kind of rationale really scares them into reporting what's happened and to addressing what's happened. And that's a huge problem. And the last difficulty that I'll mention just generally is that there's this constant tension when we're dealing with elder abuse between the well-being of the elder and the self-determination of that elder. Okay, because just because someone's older doesn't mean we get to step in and decide what they want to do that they need to do just because we disagree with what it is that they're doing. Older people, younger people, all people who are adults have a right to make a decision for themselves, even bad decisions, even decisions we disagree with. So there's always that question, is the person being exploited and abused, or are they just making a decision we don't like? And that's always very difficult too, because there are certain facts that come to being that really test that theoretical, do we step in, do we not? It can be very hard. And sometimes the abuse can continue because we don't have enough evidence, we don't have enough facts, we only know a little bit, and it seems suspicious, but not enough to really show exploitation. Victim isn't complying, victim isn't telling us what we need to know, we can't find any evidence of exploitation, we move on, there's nothing we can do. So that's another huge problem when we're talking about elder abuse. So I just want to talk generally about what we can do to start to fight elder abuse. First, we need to immediately gather and protect our evidence. Because like I said, when we're filing a petition in court, it doesn't matter if the judge likes who we are. It doesn't matter if all that matters is that we prove our case by a preponderance of the evidence if we're filing under 235F. So we need to be able to prove what's going on here. And that can be really hard if we only have one person's word. It's not impossible. It's not to say that that can't occur. We can't win on a petition just because we only have one witness. But we really need to have if it's financial exploitation, we need to have documents. We need to have documents from the past so we can show how this person tended to spend their money before and how that there's an abnormality. All of a sudden this third party came in and all of a sudden the money's going to the strip club. That never happened. We need that background to be able to show that that's not how our elder would have spent his or her money. Okay. Now, we also, if the abuse is physical, we need pictures of that. We need witnesses to be interviewed quickly so we can have them in court with us to verify what's happened if we can get them. All of those things need to be investigated quickly and they need to be gathered quickly. Because if we don't have it, it's going to be really hard if we have a vulnerable elder to only have that elder on the stand and no one else. Especially if we have a mental illness where they're going to be torn apart on cross if the other side has an attorney. Okay? Now, the other thing we need to do, as I've already mentioned, check our ageism and our biases at the door. We have to know that these subconscious things we have when we're not really thinking right now in an intellectual environment, these little things that we don't necessarily know where they come from, but these little biases that we have. For example, I have here, a male claims he was abused by a female. Well, in this space, we know that happens. Of course that happens. I don't know the statistics if it happens more or about the same or what. Probably not. But if we're out on the street and someone comes up to us and maybe intimates that he is being abused by a female, we might have that little thing in the back of our head that we don't really trust that what he's saying. Maybe he has dementia, right? I think we need to get over that because we need to be investigating and taking these claims seriously. If it checks out that it's not true, then it's not true. We know that the elder's not being exploited. But if we don't investigate these things, we're never going to find out whether the person is being abused or not. So we really should be taking it seriously. Another thing we need to do is we need to help protect one another. By the time it comes to Iowa Legal Aid or it comes to someone else, it's very possible that the money's gone and we're not getting it back. It's too late. Or it might be that the person who abused the elder doesn't fit into the categories that I'm going to go over here in a second. We can't even legally bring a petition against them. So I really hope that everyone keeps the materials today so that they know where they can turn to if they are being abused or they know of someone else who's being abused and that can be addressed. I think we all need to visit each other because isolation is one thing that happens to a lot of our older Iowans. And people who are isolated are going to be more likely to be preyed upon because they don't have anyone to complain to. They don't have friends and family that they can confide in. And even if they are being abused, maybe they can't tell someone about it, right? So we need to make sure that we're out in our communities. We need to be talking to people who are isolated so that they can come up to us if there's an issue or that we can figure out if there's an issue going on and we can help them. And I'm going to mention later, 235F has an ability for a substitute petition, a substitute person to file a petition on behalf of an abused elder. So that's going to help us out here. If we know there's abuse happening, but the victim isn't doing anything about it, we can step in and help, okay? We also need to engage in some basic planning for the future, basic legal planning. That's going to help us prevent people coming in and taking advantage of us. If our minds deteriorate or we develop something that we didn't expect to happen to us, like some sort of mental illness like dementia or Alzheimer's, if we can get that planning done in advance, it's going to decrease our chances that another person is going to come in, get us to sign a power of attorney, and then just take all our money from us. And I'm actually going to be talking about that next month. So I hope everyone comes back and we can talk about legal planning and how that can help us out. Now, let me talk about financial exploitation. I've already mentioned physical, sexual, neglect. We kind of know what those are. It's not always perfect. It's not always obvious whether someone is being abused in those ways. But I think financial exploitation is the one thing where people are most confused. So this is the law right here. When a person stands in a position of trust or confidence with a vulnerable elder and knowingly and by undue influence, deception, coercion, fraud, or extortion obtains control over or otherwise uses or diverts the benefits, property, resources, belongings, or assets of the vulnerable elder. That is a very long sentence. But I want to break that down a little bit because it's really not that hard when you break it down. So, we have, let me go to the next slide. There's really 4 parts to that, what I just read out. First part is who is an exploiter? Who can be an exploiter under the elder abuse law? Second part is who is an exploited older Iowan? Who do we say can be abused in that way? And we call it elder abuse, not just another criminal thing, theft or battery or something. What is elder abuse under the law? What is the method of exploitation? And then fourth, did exploitation occur and what was taken? So if we look at that and we apply that to any fact pattern, we should be able to figure out whether it fits 235F and whether we can have a petition for relief from elder abuse filed in court. So let's break that down a little bit more. Number one, who can exploit? Remember I mentioned the person standing in a position of trust or confidence of a vulnerable elder? Well, that's who Iowa law says can abuse another elder under this code, 235F. That would be a parent, spouse, adult child, or other relative by blood or marriage. It could also be a caretaker, someone who engages in custody, care, or protection of an older Iowan. Again, may or may not be a relative, does not have to be someone you're related to. Or it could be a confidential relationship, someone who has a confidential relationship with an older Iowan. Okay, I want to mention again that this does not...
Question.
Go ahead.
Could that include a managed care organization? Receiving resources from you and has a fiduciary responsibility to be looking out for your, not depriving you from physical health care and providing care?
Can you repeat that?
Sure. The question was, does a person who stands in... Can a person standing in position of trust or confidence of a vulnerable Iowan be a managed care organization? Can we use that?
That's not fulfilling its obligations.
That's not fulfilling its obligations. No. This is why. 235E is for dependent adult abuse. I believe I mentioned that in the beginning. I'm talking about 235F. 235F defines caretakers as related or non-related person who has a responsibility for the protection, care, custody of a vulnerable elder by contract, by employment, by order of the court, but it does not include a caretaker as defined in section 235E.1. 235E.1 is the dependent adult abuse statute, which defines what a caretaker is and further spells out that a caretaker is someone who is employed by a program or facility. And I believe that would be a program or facility under that law.
All right.
Okay? So we cannot use this against caretakers in a facility. Okay. And I'm talking about 235F. I'm not talking about dependent adult abuse. If something were happening in a facility, where a caretaker in that facility were abusing someone else, you would have to make a report to Department of Inspections and Appeals. Or if there were another type of caretaker where it was happening at home, you could do it. You could do a complaint to DHS. I'm talking about what we can do under 235F. All right. Thank you for that question. That's a really good question. So I think I've already laid that out. Sorry. Go ahead, Basin City.
Can I ask people that are doing a question to talk directly into the microphone so we might hear them?
Sure. All right. Thank you.
The previous speakers repeated our questions in this room, so it would go out to those other places because they don't hear it otherwise. Is that
Yes.
right? Okay.
And I'm sorry, I thought I repeated the question, but I hope that you guys heard what that question was when I repeated it. But I'll have everyone talk into the mic for their questions now on. So we go into the second part. Who can be exploited? Obviously, everyone can be exploited. That's kind of a silly question. But what I mean by that, again, is how does the Iowa law categorize who is an elder abuser, not just someone who's abusing generally? Okay, so that would be someone who is 60 years or older and unable to protect himself or herself because of age, mental, or physical condition. And there's a very interesting development that happened recently. Last month, the Iowa Supreme Court handed down its first decision interpreting this language. Okay, and it's good news for people who are fighting elder abuse because it allows someone to use age alone to meet the definition of vulnerable elder. It's kind of weird when you think about it, because why would you have if someone's over 60 and they're vulnerable, well, why are they vulnerable? I mean, are we going to assume that everyone who's 61 is vulnerable? I mean, it's kind of weird, but that's what the Supreme Court held, that it can be used. I don't know that that means that we don't have to submit any evidence of a vulnerability. I think we still need to be doing our due diligence if we're going to court or if we're making a petition on behalf of another person. I think we need to be connecting the vulnerability to more than just age. But we could also think theoretically, if we had a 100-year-old victim, someone who's a 100 but otherwise healthy for a 100-year-old is probably still going to be vulnerable to some sorts of scams and exploitations that someone who's 50 might not be vulnerable to. Go ahead.
That brings up a really good question that even as I mature through my life, what is an elder? I was noticing here it says 60, but you're right. I think aging has changed over the years. We're healthier longer, some of us. So some places define it as 60, some 62, some 55. Does the law look at a certain age as elder?
Absolutely, that's a great question. That goes right back to this slide. So under 235F, for purposes of the elder abuse law and doing a petition for relief from elder abuse, Iowa law defines it as 60 or above. Okay, so just the age part, but then you need to be vulnerable in another way. So the law is not meant, so this is the other tension that the Iowa Supreme Court addressed in its case. The law is not meant to just be another remedy for someone who's 60 or over for every single thing that could happen to them, right? You get into some contract dispute with someone, it has nothing to do with abuse, you bring the elder abuse statute, I'm over 60. No, right? So that's the tension. We have to define what elder abuse is. So the defining thing in the statute is they picked the number 60. Might be arbitrary, but that's the number they picked. Other states might be different. And then we needed a vulnerability in addition to that. But the Supreme Court has said, in a kind of a strange way, that age alone could be that vulnerability. And I just make that case that, we think about someone who's 100 versus someone who's 61, we can easier see how that works. But interestingly, in the case that they did that, the alleged victim was 69. So it is weird, but that's what the Iowa Supreme Court held. I do think it's helpful because we can use that if there's not a ton there for our clients, but we know they're being exploited or victimized, then we have an easier obstacle there, I think, because we can cite that case. So I just wanted to mention that because we can, if we're helping other Iowans here who are over 60, we can say to the district court, if we don't have a lot of evidence, we can say, well, Your Honor, the Iowa Supreme Court held that We don't have to have anything more than age. So, generally speaking, to be vulnerable. Okay. Third thing, what is the method? Now we have another long string of words that can be useful to us. You have undue influence. That's actually defined in the statute, 235F, taking advantage of a person's role, relationship, or authority to improperly change or obtain control over the actions or decision-making of a vulnerable elder against the vulnerable elder's best interest. That's very specifically laid out in the statute there. Then we have deception. That is not defined by the statute, so we can use our common sense there. Coercion, communication or conduct which unduly compels a vulnerable elder to act or refrain from acting against the elder's will and against the vulnerable elder's best interest. And then we have fraud and extortion, again, not defined. To me, there's not a huge difference between deception and fraud. I don't know that there is a huge difference between those things. Deception, I just looked it up in the dictionary. To mislead by a false appearance or a statement, delude. Fraud would be deceit. It actually has the word deceit in the definition for fraud. So there's not a huge difference to me for those words, and it's not defined, but I think that this is our toolbox of words that we can apply to our diverse fact patterns that we have. Elder abuse has a lot of weird things that can happen in it, a lot of weird facts, and we have diverse words we can use to apply to those facts, diverse legal terms, and that can help us out. So it's a little weird that they don't define those three words, but we can use our common sense and we can apply them to whatever facts might be facing us at the time. 4, did exploitation occur and what was taken? So again, we obtains, control, or otherwise uses or diverts benefits, property, resources, belongings, or assets of an older island. What's interesting about this language is it doesn't say anything about whether the person who's obtaining control has to use those benefits for themselves, right? It doesn't say that. It just says obtains, control, or otherwise uses or diverts property. So let's assume that a person is victimizing a vulnerable elder, all other things are met, and that person takes what he exploited from the island and gives it to a third party. Well, that would still be covered because he didn't use it for himself, but it's still covered. It doesn't require that. It's kind of another weird thing. This is just my reading of it. The Iowa Supreme Court hasn't defined all these things for us yet or explained them to us, but if you read it, that seems to be what is entailed by the language. So it's kind of odd, but again, as with any new law, sometimes it's going to be changed by the way the court defines what the language means in the statute. So let's go over a scenario together and decide whether this is exploitation or not. So I'm going to read it out to everyone. John is 82 years old, and his physical condition makes it difficult for him to leave his home. John's in-home caretaker picks up his medications from the pharmacy for him. John gives his caretaker cash to buy the medicine. Co-payment for the medicine is $27, so John typically gives his caretaker a $50 bill to pay for it. Caretaker never provides John with a receipt and never returns his change. John asks his caretaker to provide the change for the co-payments and the receipts for the purchases. Caretaker tells John, if you ever ask me for change again, I will make sure you go into a nursing home. I'll tell your doctor it's not safe for you to live at home anymore. The caretaker knows there is no basis for the threat. It is difficult for John to report what the caretaker is doing because his caretaker has to get his telephone for him when he makes his calls. Is this financial exploitation? I hope this is a very easy example that this is obviously financial exploitation, but let's break it down why that is the case. So let's go through our 4 elements that I've already explained. First, is John an exploiter under Iowa law? He's a caretaker, so clearly he stands in a position of trust or confidence. That's right there in the fact pattern. He's a caretaker at home. Therefore, he can be an exploiter as under the 235F law. Number 2, is John a vulnerable elder under law? He's over 60, and we know he has a limiting physical health condition, so he is definitely a vulnerable elder. If he were just 60, it might be debatable because of the Iowa Supreme Court case that I brought up. But there's an argument that can be made if he was only 60. But if we show the physical limiting condition clearly connected to the abuse, not being able to help himself when he's being abused, we know he's a vulnerable elder. Third, what's the method? What happened? Well, many words could be used to describe the behavior of John, pardon me, not John. What's the caretaker's name? I forgot. Oh, I'm sorry, I didn't give him a name. There you go. The caretaker he knowingly and by undue influence, coercion, and extortion threatened to put John in a nursing home for asking about his money. So you could apply all those words to the behavior of the caretaker here. So we know we can use that. And then fourth, what was exploited? The caretaker diverted resources meant to pay for John's medications by never giving back his change. So we know this is a clear example of elder abuse. Specifically, we know it's financial exploitation. So what can he do? What can John do when this is happening? Well, he could report the abuse to the Iowa Department of Human Services, as I mentioned earlier. But remember that DHS only looks to dependent adults. Here, he's arguably a dependent adult because of the facts of the case that I said. He can't get the phone. If that's an activity of daily living. So maybe DHS will look into it. He could report it to the police, the theft. Now that's going to bring in a lot of those things that I talked about at the beginning. Remember those biases, the ageism, or just the lack of evidence? There might not be a document trail here. It might just be that the elder is saying, my money's being stolen, but he gave cash to the caretaker. How are we going to back that up? He comes to me, he calls me on the phone. How am I going to prove it? It's in cash. We need to be, again, keeping our evidence, as I said at the beginning. They could contact the Iowa Legal Aid's hotline for older Iowans. And if the case is an exploitation case, it might come to me because I'm working on those cases. So I could give advice about what the alleged victim might want to do. It's possible that we could give direct representation to certain people. So they would definitely want to call. Again, it's free, as I believe Scott pointed out. So anyone who's over 60, call. It's free. You could also call your Iowa Area Agency on Aging. This is not going to be for legal help. They're not going to be able to help you. They're not lawyers, but they might be able to point you in the direction of maybe getting a new in-home caretaker or other ways that they can assist you if your money's been stolen or whatever it might be. It's a great resource. I work with some of them on some cases informally. Or you could John could file an elder abuse petition. Okay, and I'm going to talk about what that entails, what's required, and all that here in a second. But let's go over another scenario first. Okay, John is 75. John's grandson, Charles, who is a legal adult, but is not John's caretaker, approaches John one day. Charles tells John that John has to sign a certain legal document. Charles says that if John signs a document, he'll get money from a lottery he just won. Document's actually a financial power of attorney that would allow Charles to act for John in financial matters. John didn't win the lottery and, in fact, never entered a lottery. John signs the document. Charles takes the document to John's bank and withdraws $700 so he can buy a television for himself with it. Is that financial abuse, financial exploitation? Well, let's go through our elements here. First thing is Charles, can he abuse John pursuant to the language of the statute? He stands in a position of trust or confidence because he's related to John. Remember I said he's not the caretaker, but the 235F statute broadens what we can do against elder abuse. Before, if they weren't dependent adults, they didn't have a caretaker, and it was just a family member who was abusing them, they didn't have any recourse. They'd have to go to the police. That was it. Well, this statute lets it so that if we have family who are abusing us and they're related to us and we otherwise fit the vulnerable elder definition, we can bring this petition that I'm going to talk about after this. So, he's likely a vulnerable elder because he is well over 60. If he had dementia, it would be a clearer case because that would be a mental condition that would be connected to this abuse. Obviously, the fact pattern suggests that he might have he signed a document, he thought it was a lottery document. That seems sketchy to us, but we don't know on the facts that I gave you whether it could have been an elaborate trick It could, could have been a fake document where he took the signature off it and put it on another document or something crazy like that, where any of us might have fallen for it. So we don't know. But if he had dementia, it's probably a clear case of financial exploitation. He deceived John by lying about what the document was, and resources were diverted because funds were withdrawn from John's bank account. So this is very likely financial exploitation on the facts. So again, what can be done here? We can report the abuse to the Department of Human Services, but that's not always perfect because remember, they only do dependent adult abuse. And right here, what did I say? He's just a relative. He's not a caretaker. So DHS might look at this case, even if they have the proof, and say, we can't do anything about it. I'm sorry, he's not a caretaker, right? So let's move on. He could call the police, but again, we have those, maybe the police is going to look at that, the police who are investigating are going to look at that document and say, well, you gave him a power of attorney. This is a civil matter. I mean, there's a document right here you signed. Or, maybe the abuser says, well, he has dementia. He signed this a long time ago. Maybe he forged the year it was 10 years ago he signed this power of attorney. Now he doesn't remember he even signed it. And the police say, oh, that sounds reasonable. Sounds like a civil matter. I'm not getting involved, right? That could happen, and maybe it doesn't. Maybe they investigate, maybe they prosecute, but we don't know. You could, again, contact Iowa Legal Aid's hotline, and attorneys might be able to talk with you about your case, give you some advice on what to do. They might be able to give you direct representation to file that petition under 235F. You could, again, call your Iowa Area Agency on Aging for assistance and guidance, or you could file your own petition. Now let me talk about this petition that I keep mentioning under 235F. This is, again, a pretty new law. As I said, the Iowa Supreme Court has only recently interpreted it for the first time, specifically that what is a vulnerable elder. Of course, there's other language in there that might need to be interpreted in the future. Now this can be filed by an alleged victim or a third party. Remember I said at the beginning there could be a substitute petitioner on behalf of an alleged victim. That is so helpful to us and important because by statute we're dealing with vulnerable older Iowans. So they might not be able to file a petition. So we need people to be able to help them sometimes, people who have knowledge of the abuse that's occurring. So this 235F law makes it possible for someone to do that for someone else, and I think that's a great thing. Petitioner is not required to have an attorney. That's always advised, but they don't have to have an attorney. They can file it pro se. They can go down to the courthouse and just fill it out and have a hearing. If the substitute petitioner does file, so if you were to file on behalf of another person, the alleged victim still has rights to come to the hearing. They can still present evidence. They can still come in and contradict everything the substitute petitioner says. The person could be doesn't believe they're being exploited, deluded into thinking they're not being exploited, whatever. They could come in and say, Your Honor, I don't want this petition filed. I want it dropped. And then it's going to be up to the judge to figure out what the heck's going on. And of course, that would be a very difficult case, but it's possible. Another thing I'd like to mention, it's not on here, but venue. So where do I file this petition? There's all these different parties. Venue is where the alleged victim or the substitute petitioner reside. Okay, so that could technically be two different counties. But the safest thing to do is if you're filing the petition, file it where you live. That's probably the safest thing to do and probably what I would recommend most people do. This petition is available online. Okay, if everyone goes, I have the website right here on Iowa Courts. You can go under the Court Rules and Forms tab, kind of at the top, and there's an elder abuse form, I believe, towards the bottom of that Court Rules tab. That can be, you can look at what information you need to put in specifically to get this petition on file and to move forward with the hearing. There's no filing fee. Okay, so you don't have to, like small claims is like an $85 fee in Iowa. That's a lot of money for especially a lot of my clients who can't even send me documents because they can't afford a stamp. So this is another great thing because they can file. They don't have to pay any money to file. They also don't have to pay any money to have it served. You know, whenever you do a civil petition in district court and you have to serve, you know, you're going to pay the sheriff $50 for that. Here, the sheriff is going to have that served for free. Now, the cost could be assessed later, but we know to get it done, it's free. The hearing is going to be set really quickly. Obviously, the nature of the what we're talking about in court here is abuse, so they're going to have a quick hearing. It's going to be 5 to 15 days after the date the petition is filed. And what can you get from this petition? What can the court do? Well, the court can enter an emergency protective order. You know, that could be the abuser can't have any contact with the alleged victim. They can do an emergency one, you know, where they say, you know, until we have the hearing, no contact. Let me figure out what's going on. They could order the defendant to move from the residence if they share a residence with the alleged victim, or they could assist the victim in obtaining alternative housing. So they could have a police escort come in and help that alleged victim out of the home into another place where they're safe until the hearing is had. They could restrain the defendant from exercising any power over the alleged victim. So if there's a power of attorney document that, you know, was deceptively signed or something like that, the court could say, you're not going to use that document. The documents used, they would be in contempt of court. That gives you a remedy there to stop that sort of behavior from happening. They could order the defendant to return the property to the alleged victim. That's obviously another thing that's very important. Whatever has been taken can be, if you can prove it. Remember what I said, we have to have proof. So if we come into court and we just talk about, well, I think I gave him $200, but I don't quite remember, you're not going to be able to prove up your damages. We need to have documentation. So I encourage everyone to make sure we're keeping documentation of all our finances, particularly as we're getting older. What can't you do with a petition? One thing you can't do is the elder abuse petition cannot affect an interest in property. So let's say we have someone who deeded a home to someone else. They were exploited into doing it for some reason. They were deceived. Their signature was forged. Who knows? There's something that happened. Home was deeded. Shouldn't have been deeded. Obviously, in a general sense, it's abusive. It's exploitation. Court is not going to be able, through 235F, to be able to avoid that transaction. A petition in district court is going to need to be filed to clear up that title. Okay, so we can't use 235F if we have some sort of real estate dispute. Okay, because that hearing is really quick and there's really no discovery in it. So it's kind of an issue that the court really can't deal with in that manner. So it makes sense. Now let's talk about another scenario. Now, before we talk about the scenario, I want everyone to pay attention right now, because there's a small typo in here where it says grandson Charles. I want that to say son. I don't want to confuse anyone. Please put son, not grandson, because that is a typo. And I'm actually going to talk about that in a second, why that's interesting. Let's talk about the same scenario as before. John's son, Charles, deceives him into signing a power of attorney document, except John's son is not a legal adult because he's 16. Okay? Charles is not John's caretaker. Is that financial exploitation? Well, I mean, yes and no. Obviously, again, it's immoral, it's illegal, shouldn't have done it. But what does the elder abuse statute say about financial exploiters, who they can be? They have to be adult children. Okay? And I said he's not an adult. Therefore, we can't use a petition if Charles is the son. Okay, so the lesson here is that even with this expanded law, there are some fact patterns where there's not much we can do about it besides call the police or file a civil petition in court, in district court, or small claims depending on how much money has been taken or whatever. So we need to thwart this stuff before it happens, because once it happens, sometimes it's too late or we don't have a remedy, right? Now, I want to talk about what's interesting about that typo. Remember I said I had grandson in there? The 235F statute defines family to be, hold on, trying to find it here. I want to read the exact thing. Family means parent, spouse, adult child, or other relative by consanguinity or affinity, blood or marriage. Okay? The adult child, the adult part doesn't seem to modify the other relative part. It's kind of weird. It's just something we noticed when we were really digging into this statute. It's strange because think of the following scenario that we discussed yesterday, Scott and myself. Think of an elder. He's a vulnerable. Let's just assume he's vulnerable. He's being exploited. The two people who are exploiting him are in cahoots. One is his son, who's a child, and his nephew, who's a child. If we apply this literally, the court's only going to be able to do something against the nephew, not the son, because it has to be an adult child. Does that make sense? I don't know. We can't figure out. It's kind of a weird way it's written. Maybe the adult is supposed to modify that. Maybe it's not. We don't know. But that my reading is adult child or other relative regardless of age. The other interesting thing is that in this statute, it does provide for waiver to juvenile court. So we know it can be filed against legal children. So that would seem to suggest that our reading is correct, that we're talking about if it's a nephew and a son and they're both children, only the nephew would be, we'd be able to bring this petition. So I only say that again because I think it's just a little interesting. And there's not always something perfect. There's not always a perfect remedy we can use to fight elder abuse. So we really need to be thwarting it before it happens, okay? And I will leave us with just some thoughts again. Community vigilance, we need to be getting out into our communities and talking to people who are isolated so they have people they can talk to about these issues and let us know what's happening so we can actually do something about it. We need to do our legal planning, which again I'm talking about next month, so I hope everyone comes back. And we need to raise our community conscious about this law that can be helpful to us, 235F, and all of these problems that we face when we fight elder abuse so that we can better fight it together. With that, I really appreciate everyone coming, and I'm happy to take other questions from anyone. Yes?
Well, sorry, because I don't have a mic.
She doesn't have a mic, so I'll talk into it for everyone.
So, in the example of the person, watching out for your finances, but in the case of the person who gave the caregiver money and they're not getting any change or receipt back, what would you suggest, since many older adults are comfortable with handling money, but not, say, a debit card or, but of course then they could be open to more exploitation with the debit card, but what would you suggest, because that's probably a very common situation. What would be a simple solution for that, so the person, if we're watching it happen, we could see what to do and help them take some steps to not have that happen.
Okay, so the question is, in the case, one of the scenarios I mentioned where, let's say a caretaker is taking money from a vulnerable Iowan and not giving the change back, what can they do to try to remedy that? What's a simple, common sense thing they can do? I really think, so the cash thing, I know that's common, as you said. It's common for, debit cards and credit cards are obviously a lot more common now than they were in the past. So culturally, older Iowans might be using cash more than younger Iowans might be. I don't know if that's true or not, but I would think that's probably true. So I would again encourage everyone, we need to be documenting all our transactions. So, they need to have a card that we can show what was exactly paid for. We need the receipts. That needs to be demanded. We need to have our receipts from the people if they're taking our money and they're buying something on our behalf. We need to be able to verify exactly how much money they paid for it. I mean, that's not an unreasonable request. And in my example, obviously, it was kind of extreme because the lady wouldn't even let him complain to someone. But if someone called me and told me my caretaker won't let me have my receipts, I mean, that's clearly unreasonable, and that would be something that an outside party can investigate and help that person with. But we need to demand that we have our receipts so we can document everything that's being spent. Another question.
What about an elderly person who has no immediate family in the area and some church caregivers have taken over for her, and they're refusing to pay for her care, but they're elders of a church and they're giving large sums of money to the church, but refusing to pay for direct care needs of the elder Iowan. But they're the only person that will help this person because they have no immediate family and this person has dementia.
Okay.
Would that be?
So I'm just giving a scenario. What if a church, let me make sure I'm getting this right. What if there's a church where there's we're going to assume this is a vulnerable island because
Very vulnerable
the
island.
person has dementia and they're giving large sums of money to the church.
They're the church elders, and since this person has no family, they're going in and they're writing large checks to the church that they're the elder of.
Okay, so
But are declining from her account, but declining to pay for her care needs,
I
saying
see.
she doesn't have money.
So this person with dementia is writing large checks. She's an elder of the church. She's writing large checks to the church. Has dementia. They're not giving anything back to her. They're not helping her in any way with her medical needs.
It's a
anything
fight to
like
get
that.
them to take her to the doctor if
Mhm.
she's trying to the doctor. or
But
no problem,
but they're coming in to help a little bit.
if forced.
hmm Well, I don't think that they would fall under this is questionable. Okay, this is something I don't know. This is something we would have to research. My inclination is it's probably not going to fall under the statute, the dependent adult facility or program. It's probably not going to fall under that as defined under their statute. So really, there could be a remedy here. It's possible. To me, when I hear that, I mean they're accepting money. I think that's just generally immoral, but probably could be illegal under this petition. But
Under elder abuse.
it could be, yes, because if they're coming in giving caretaking, they've assumed that role, even voluntarily, non-family, not voluntarily, not getting paid for it. That's still a caretaker, okay? Because they're not a facility or program, best I can tell. So that could be remedy, and the person is clearly vulnerable. They're over 60. I think their money's it could be being exploited, maybe, depending on are they exerting, should they not be taking this money? So there might be, is the short answer. The long answer, I should say.
Are they writing the check? So,
Well, they're-
if they're on
The
her
church
account,
elder is writing
Wait.
checks on her.
So I'm sorry, the church is writing the checks. I was thinking that the person with dementia was writing
The person
checks.
with advanced dementia can no longer manage
If
their
the-
money, so they have her checkbook.
If the
and they
church is
write checks
managing the
to their
money
church.
and writing checks, I don't care what organization that seems like exploitation to me under the law.
Well, we call
So.
it dependent adult abuse, and they say it's not.
Well,
Do they have power of attorney?
I'm not sure.
we're not sure if they had
It's
power of
some
attorney.
kind of- Even if they did, it won't pay for her direct care needs, but are putting large sums of money into the church that they're the elders.
Well, do we have another question about that?
Well, then if she becomes eligible for Medicaid because she's lost her funding,
It's already on Medicaid.
she's already on Medicaid,
She's already on Medicaid.
So she has a very limited income anyways.
Well, that scenario is definitely very questionable and something that I think would need to be investigated. And it does appear, based on what you've told me, to fit the statute. Any other questions?
Well, if someone saw that, where should they turn?
Where should they turn if something is happening like that? Well, it sounds like they already turned to DHS, but they didn't, for whatever, they might not have determined that they're caretakers, for example. Oop, my name tag fell off. They might not have determined that those were proper caretakers under the dependent adult abuse statute.
Andrew, is the thing down? Oh, the clip's still on there, okay.
I hope everyone can still hear me. Okay, so report to DHS. They may or may not do something. Report to their police. The police probably aren't going to touch this. Okay, this is one of those weird, they're going to say this is a civil issue. I almost guarantee it. They might not. I don't know. Okay, but with what I know of what happens, they're probably not going to do anything. It's not going to be a criminal thing. What they need to do is they need to file their own petition, like I said, and they need to call Iowa Legal Aid so we can at least advise them, if not give them direct representation. And that's going to depend on whether we can do it or not. But at the very least, we can give them advice, assuming they don't conflict out or something like that. We should be able to give them advice on what to do. Okay, so I would encourage them to call Iowa Legal Aid, file their own petition if no one else can help them, if they can afford a lawyer. They can pro se file their petition. They don't have to pay the filing fees. They don't have to pay the service. They go to court. And hopefully we can at least help them with the basics if we can't give them direct representation. But as I said, remember at the beginning, lack of resources. Wouldn't it be nice if there was some other thing? It's not my job to vie for that, but it is what it is. Go ahead.
How about your elder rights specialist at your area agency on aging?
That is another great thing that I should have mentioned. So I'm glad that you said that. Thank you very much. They're not gonna be lawyers at the Area Agency on Aging. The question, it wasn't really a question, but for everyone listening, it was just a statement. What about the Area Agency on Aging?
Elder rights specialist.
An elder rights specialist there. That's very right. I actually work with one very closely informally on certain cases, and they will be able to direct you to other resources, and might be able to make some referrals. They might be able to help. Okay, so they might have some resources in place. So that's another great thing. I'm glad you pointed that out. So thank you very much. Any other questions?
Yes.
Okay.
Caretaker is concerned but not directly aware of a financial exploitation by somebody else. Is that caretaker chargeable under this or anything else?
Well, so the question, did everyone, you had the button down, right? Okay, so everyone heard the question. First of all, the word you used, chargeable, so this is not a criminal statute. This is something that any person could file, just to clarify for anyone listening. That's a very good question. Very good question. I don't know if I've ever thought of this before. If they have knowledge of it and they're not doing anything, I don't know if under the law they would be the exploiter. You know, it's kind of back to that weird, are they in cahoots and there's a third party getting it?
Assume not cahoots.
Assuming not in cahoots, I don't think it would, because the statute seems to say that the person who is the exploiter needs to be diverting the resources, and that needs to be the caretaker. And if we're talking about a third party who is not a relative or a caretaker, or is not in a confidential relationship, then 235F does not apply. So if this person that you're talking about, this third party, is not a caretaker, not a family member, and not in a confidential relationship, we're not going to be able to use it. Okay? If they somehow fit one of those things, we might be able to go over to the person who's actually doing the exploiting. But as far as I don't know that just having knowledge of something is going to fly under this statute.
Well, changing it over to the civil arena, and you can say you can't comment on that if you want, but I'm not a lawyer, so.
Oh, no, that's fine. That's fine.
Somebody else has a beef with the caretaker over that issue. Is this something the caretaker should be concerned about?
I mean, obviously the caretaker should be concerned about it. I just don't know if it really depends on the facts, if we're going to be able to characterize this as elder abuse or not. So, I really, without knowing the facts, I'm guessing you're talking about something in the real world, and you're just giving me some hypotheticals here. And I'm happy. Okay, and I'm happy to talk to you, or have you call our hotline so we can get into the facts a little bit more, which I don't want to do here because this is not confidential in this room, and I don't want to give advice and establish a client-attorney relationship before we've done our intake procedure. So I'm happy to talk to you about that, and Iowa Legal Aid is happy to talk to you about that. But it's questionable. It's a great question, and I don't know without knowing more facts. Any other questions? Go ahead.
How do the police determine whether it's civil or criminal?
Okay, so how did the police determine if it's civil or criminal? That's a great question. Sometimes I get complaints.
It sounds like they're getting a pass on if you're over 60. They just call it elder abuse, and if you write a check on someone else's account and I'm 40, wouldn't that be criminal? Well,
they're reluctant to get involved because of the many things that I talked about in the beginning, right? They might not know that subconsciously that maybe they need to be looking a little more seriously, but they can't. But let's think about it from their perspective, though. They're going to go to their boss and say, "Boss, I think someone's being exploited, and I want to," and the boss says, "Well, okay, what evidence do we have?" "Oh, well, another random person called in and told me that. I don't have their name." Let's say that. And then the cop goes to their house and he says, "Are you being exploited?" And then the person has dementia and can't even answer the question. We have no evidence, let's say. I mean, is that cop going to go to the prosecutor and say, "I got the best case ever for you today that you need to take in front of a jury"?
True.
And when resources are stretched thin and we have to decide whether we're going to go against that or we're going to, maybe drop the rape case over here, that's solid, let's just, from their perspective, there's reasons why sometimes they don't. It's not that they don't care, okay? I'm not generalizing, it's depends on every department and every detective. But there's reasons why they're going to say, "I'm sorry, but this is not something we're going to get involved in." And again, remember there's that tension between self-determination and safety, and we don't want to overstep and have a cop come in and say, I think you should be making this decision, right? I mean, could you imagine the outcry if someone comes in here and says, a cop came over and told me that I gave money to my daughter and that was exploitation, right? They have to avoid that appearance too. So I just that's a great question. I point out the realities are that there are reasons why sometimes they're not going to do it. And elder abuse is really hard to fight. So going to the police is probably, unless we have good evidence, probably not going to get us pretty far. Okay. Any other questions? All right. Well, I thank everyone so much.
Come back in April.
Come back in April. And if anyone's listening, I'm wanting to give this talk to other facilities and other groups. So if you would like to have me do it for free, please contact me. My information is on the beginning of the booklet that we have. Thank you again. My name is Andrew C.